Good afternoon, everybody. Thank you for joining us today for the third session of our speaker series this year. A very warm welcome to our regular attendees. And if you're new to this series, I want to extend a special welcome to you. And please take some time to introduce yourself to us. My colleagues in the room with us today, Marvin Schottland, our CEO, Dan Rothblatt, Ellen Rosen, and of course, Karen Friedman. I also want to recognize the many members of our Board of Trustees, Board of Advisors, and I think we have grantees joining us today as well. I'm very pleased to welcome Paul LaMartina as our speaker, and I'm so appreciative of Paul taking time from his schedule to present to our group today. His presentation and bio were sent to you earlier today, and you'll hear from him in a moment. You know, I'm often asked why someone should open a donor-advised fund with us instead of their banking partner, especially when our fee is a bit higher. What I want to emphasize are two premier things you get when you partner with us. First, we're a very experienced and professional staff that's a resource to vet charities, to be a sounding board and advisor to donors and their families. And for those that want to learn about charities or get involved beyond writing a check, we help with that as well. And we do that for any donor to the foundation. Secondly, we take the fee we charge and turn that into grant making. We make our community better, not for our own profit. Every year, we take the fee that we charge and we turn that into millions of dollars of grants to help charities get started and thrive so they can further help our community. This month, in Pride Month, I'm so pleased to be a part of a foundation that's given very significant support to groups that support our LGBTQ+ family members and so many other groups that make up our beautiful and diverse community. If you want to learn more, reach out. We'd love to talk with you about how we work and how we can help you and your clients. I just want to remind you that during the program, please send your questions to me using the chat button at the bottom of your screen. Although I know Paul is very adept at this, so you might chat with him as well. We'll do our best to get to all the questions at the end of the program. And we don't have a hard stop, so if questions go a little over, that's okay. Paul, I'm going to turn it over to you. And thank you again for being here to do the presentation.
Great, thank you, Steve. Very excited to be here. This is one of my favorite topics to present on. And I do enjoy addressing people's questions. So if there is anything that you want to ask, please put it in the chat. I'll try to address them as I go, but if not, we'll have a little bit of time at the end where we can go through everyone's questions. So a little bit about me. I'm an estate planning attorney with Jeffrey Mangels, Butler, and Mitchell. I'm based out of our San Francisco office, but we do have offices in Los Angeles and in Orange County. And I've been practicing as an estate planning attorney for about 8 years now. When I first started out, the first law firm that I worked at had a focus on estate planning for LGBT individuals. So that was kind of my introduction to estate planning. So one thing that I've been asked quite a few times when speaking on this subject is, isn't planning for LGBT people the same as planning for everyone else now that we have marriage equality? So I always just kind of like to address this off the bat, but because the answer is yes and no. What I find is that even though the same issues come up for both heterosexual and homosexual couples, there's a lot of fact patterns that are very common in the LGBT community that I don't see as much in the heterosexual community. So I want to sort of go through some of these issues today. Hopefully it will give you a little bit of a basis to do issue spotting off of. And again, if you have questions on anything or want me to talk in more detail on any of the topics, please just let me know and I'd be happy to do so. So as sort of a brief overview, these are the main topics that we're going to go through, sort of what the current law is. One of the most important things when you're working with LGBT couples is determining the marital status. So I'm going to talk about that for quite a while, talking about sort of what the different options are and what the effects of the different types of statuses are. Planning for children, another big topic for LGBT couples. There's a lot of issues that heterosexual couples don't run into, they don't run into it as frequently as LGBT couples. There's some sort of family and societal concerns to just sort of have on your radar. I'll talk about issues that are kind of specific to transgender and non-binary individuals. I also want to go through just sort of the basic estate planning documents, how we address clients' issues, what the documents are, and how they work. I want to go through a few tax planning issues, and then I'll finish off with just some tips for how advisors can sort of serve their clients better. So one thing is, it's been a quickly changing legal landscape. When it comes to marital status, you only have to go back to 1996 to when the Defense of Marriage Act, which defined marriage as between one man and one woman for federal purposes, was introduced. After 1996, over the course of the next 2 decades, things were changing every year. So in 2000, Proposition 22 passed in California, and that was a voter initiative that led to a statute that said that marriage in California is between one man and one woman. So that was the case in California for about 8 years before that statute was struck down as unconstitutional. That ruling came in 2008. Shortly after that, there was another voter initiative to pass Proposition 8, which was actually a constitutional amendment to define marriage in California as one man and one woman. And that was the case for another few years before that too was struck down. Now, more broadly across the country, prior to sort of the Windsor and Obergefell decisions, there was, I believe, 29 states that actually had constitutional amendments to say that marriage is only between a man and a woman. And there was 31 states with some type of statute to the same effect. So in the mid 2010s, the first case that came out was Windsor. This was a 2013 Supreme Court decision, and it was a tax case. So the issue was that a surviving spouse, she was married to her wife in Canada. They moved to New York. Her wife passed away, and there was an estate tax due, even though everything was being left to the spouse. So the reason for that is, since marriage under the Defense of Marriage Act was defined as between one man and one woman, because it was 2 women involved, there was no marital deduction allowed for estate tax purposes. So this was found to be a violation of the Due Process Clause, and the Supreme Court allowed basically the marital deduction for the property passing from the deceased spouse to the surviving spouse. Shortly after, in 2015, there was another case that came out, Obergefell, and this one is the case that basically allowed for gay couples nationwide to be married regardless of whether there was a statute or a constitutional amendment that banned same-sex marriage in their state. It was a split decision. There was 4 justices that dissented, notably Chief Justice Roberts, Justice Thomas, and Justice Alito all dissented, as well as the late Justice Scalia. So there's been a lot of talk recently about whether going forward, we're still going to have marriage equality, given that the dissenting justices are still on the Supreme Court, and that there's been a shift to sort of more conservative justices currently. Now, one of the interesting things is, if we do go back to where some states allow and some states don't allow same-sex marriage, sort of what the legal status is going to be for individuals who were married and now their state won't be recognized under state law. So there was a Texas case that came out shortly before Obergefell. And in this case, it was a couple that had been married. I can't remember what states they were married in, but they moved to Texas, where same-sex marriage was not allowed under the state constitution. So basically, the lower court said that they could not obtain a divorce in Texas because the marriage was not valid. And this got moved up to the Texas Supreme Court, where it actually was dismissed because one of the individuals who was seeking the divorce died while the hearing was still pending. So it's going to be a question of whether sort of the full faith and credit, where what's done in one state has to be respected by another state, will overrule sort of state level constitutions. So I think that's still an open question, and it may be that we see how that turns out in the nearest future. Now, prior to Obergefell, what a lot of states were doing is they wouldn't allow same-sex couples to marry, but they would allow either a civil union or for them to enter into a registered domestic partnership. So with LGBT couples, it's really important to determine exactly what type of relationship, what type of legal relationship they've entered into. Because we do still see a lot of individuals that are in a civil union or registered domestic partnership. Now, here in California, since 2020, domestic partnerships have been open to both same-sex and opposite-sex couples. So it does come up with potentially with all individuals. But the reason why it's important is that registered domestic partnerships are at the state level, but it's not a marriage at the federal level. So the difference that comes in is really when we're talking about tax issues, property rights are always determined at the state level. So for example, in California, registered domestic partners can form community property with each other, but they're not going to be considered married for federal tax purposes. So when you've entered into a domestic partnership in California, you might be filing a joint income tax return with your partner to California, but you'll be filing as single individuals to the federal government. Now, there's also sort of a subset of registered domestic partnerships. Here in San Francisco actually issued their own domestic partnerships prior to it being available under California law. So if a client entered into a sort of county, city level domestic partnership, the same benefits of having community property won't be available to that individual or that couple. The other big thing is I just always like to flag that this LGBT issues are constantly evolving. There was a recent case about Social Security survivorship in Eli versus Saul. It was, I believe, an Arizona case. And the individuals were together for over 3 decades. However, they were married before they died. However, there's a set amount of time that you have to be married in order to receive survivor's benefits through the Social Security Administration. And because same-sex marriage was banned in Arizona until about 5 months prior to the individual passing away, they were never able to actually be married for the entire survivorship period. So the question was whether the survivor was actually eligible for benefits. So it went up to the Supreme Court, and the Supreme Court actually did allow those benefits. The next case that I've cited there, Bostock, that's a Title VII case, so it's employment. I believe this was out of Georgia, and there was an individual, he worked for the county, and he had always had a just exemplary record, positive performance reviews for years, and then he came out to his coworkers. Some of the coworkers, I guess, did not appreciate that he was a gay man. He faced discrimination. His history of positive reviews suddenly turned to receiving negative reviews. He was the recipient of a lot of derogatory comments, and it was a question of whether this was sex discrimination that was protected under federal law. This one went up, and it was confirmed to be sex discrimination, and the gentleman did win the lawsuit. And then in California, one thing is there's a federal anti-discrimination law, and then there's state level as well. California has one of the most robust systems of basically anti-discrimination that does protect both sexual orientation, gender identity, but that's generally not covered in a lot of other states' anti-discrimination laws if they have one on the books. So whenever clients are coming from another state or if they're preparing to leave California, I think it's just good to know that they may have been on the receiving end of discrimination, and that can sort of have an effect on how people present themselves in a professional environment. Now, since same-sex marriage has been illegal, there's kind of been a shift on the types of legal cases that we've been seeing. So now there's been a lot of different laws that have been aimed at transgender individuals. So I put up some stats there from last year and from this year, but we're really seeing a big push in more conservative states to do things such as prevent transgender individuals from playing on sports teams of the gender that they identify with. So again, this is just sort of things to have in the back of your mind. And I want to move on to sort of go back into marital status in a little bit more detail. So I talked about why it's important to determine marital status, and it's really because depending on whether you're married or you're in a registered domestic partnership, the tax consequences vary, and it can lead to pretty confusing results. The other thing that I want to point out on this slide is that one thing that I sort of alluded to is prior to same-sex marriage being allowed nationwide, there was issues where people would be married and then they moved to a state where they weren't allowed to enter into a divorce. So I've only ran into this a few times in my career, but sometimes there's individuals who haven't been with their ex-partner for a great many years, but they were never actually able to obtain a divorce. So that can cause serious complications when you're doing planning with the client. So my approach has always been trying to push them to really go through, get the paperwork done and filed to dissolve that relationship. And another LGBT issue, which I've run into pretty frequently, is I've had clients that they just don't want to get married because either it was never an option for them. One thing that I go through pretty frequently with LGBT clients is they'll want to know, how is marriage going to affect their taxes? Because they've been together for decades. Marriage was never available as an option. So a lot of times they're not really, there's no strong desire to enter into a marriage. But if it's going to save them money on the tax side, then they might be open to it. So it's one thing that I've had countless LGBT couples ask me about, what is the tax ramifications? And I've only had one or two heterosexual couples sort of go through that analysis with me. Now, when you run into a situation where that older generation doesn't want to enter into the marriage, there's another big issue that pops up when I'm entering into doing estate planning with a couple, because they'll be legal strangers even though they've been together for however long they've been together. So we have to make sure that there's documents in place that ensure that they're able to make the decisions for the other partner. And we're going to talk about those basic documents later in the presentation. Now, children, there's a lot of ways that people have children nowadays. It's actually a pretty fastly evolving area of the law. And one good thing about practicing in California is, since we're generally socially progressive, a lot of the issues that same-sex couples will run into in other states are avoided here. Because with the same-sex couple, it's pretty rare that there's going to be a biological connection between both of the parents and the child that they're raising. It might be that that there's no biological connection, that it's been an adoption, or that they've adopted their child. There's second parent adoption issues where sometimes an individual had a child with a previous partner, and then they're now being raised in a household with two parents, but the second parent is a legal stranger to the child. So they have to go through sort of a second parent adoption. There's a lot of couples, they'll use donors or they'll use a surrogate in order to maintain a biological connection to their child. I've had some clients where one woman donates the egg that's then artificially inseminated, and then it's transplanted into the other wife's uterus in order to be born, so that there's that sort of connection between both parents. But the big thing, I don't expect anyone to become an issue on sort of all of these different issues that come with gay couples having children. But I do like to just have that issue spotting awareness, because there can be custody issues when there's a divorce between spouses. And this happens in both heterosexual and homosexual couples, because you might have a bio parent and a non-bio parent. Now in California, if there's a presumption that applies to all married couples, where if you're married at the time that the child is born, that both spouses are going to be the parent of the child, and they can be listed on the birth certificate. In other states, that's not the case. So if there's people that are coming from another state into California, it might be that even though they had the child together, only one of the individuals is going to be listed on the child's birth certificate. So in those cases, I usually refer them to to an attorney that specializes in these issues to determine if there's any action that's needed in order to make sure that we're able to form that legal relationship between the non-biological parents and the child. Because if there isn't a legal relationship, then you can run into a custody issue if the biological parent dies. Since the non-bio parents, if they're in a different state, might be a legal stranger to the child, they won't automatically be granted custody over the child. Now, this usually will sort itself out in the probate court, but in these cases, it is important that the person's prepared a will, prepared a nomination of guardians to talk about who the correct person to take care of the child is after their death. In the absence of that, it can lead to a custody battle, which is typically in no one's best interest. Now, donor agreements, there is a wide variety of donor agreements. One of my friends is going through this process right now where she's using donor sperm, and what she decided is that she didn't want the child to be able to make contact to the donor until they've turned 18 years old. There's different levels of There's different methods of staying anonymous and what sort of level of anonymity that you want. So these are typically worked out with the donor through the sperm bank. And sometimes the child is able to form a connection more easily. Sometimes the parents are blocked from access on who the donor is. It all kind of depends on what the facility offers, and it's all just contractual agreements. Now, again, when people are living in California, we're generally very socially progressive. When they move out of state, it's just important to make sure that if there isn't that connection between the that legal connection between the non-biological parent and the child, that they're aware and that they speak with someone who specializes in these issues in the state that they're moving to point out any issues that they might want to go to before they leave California, because generally it's easier to form those relationships here than in some of the other states. I also run into a lot of family issues where, especially just given the history of discrimination, sometimes individuals have been disowned by their family members, where they have poor relationships with siblings, with parents. And this can lead to a lot of emotional issues, but the area that I'm always focused on is sort of the legal ramifications. So this goes into a little bit what we're going to talk about, the estate planning basic documents that everyone should have in place. Because in the absence of that, those individuals that they have had a falling out with may be the people who are actually entitled to make legal decisions for an individual when they're incapacitated. There's also, and this I run into quite frequently, there's an issue when there's a couple and one of the couple's family may not be accepting of the individual's partner. So you have to figure out how to make sure that that partner is recognized, legally speaking, and ideally respected during the other partner's life. Again, it's to avoid any sort of interference in medical and financial decisions. And the other one is it's to ensure that after someone passes away, that their assets go where they want it to go. So there's different methods that we use to prevent these types of contests. With healthcare directives, there's certificates that I'll frequently attach to someone's healthcare directive that basically says that I've walked through the document with them, that they understand the ramifications of the document. And this can help prevent a family member from challenging the healthcare directive. There's a parallel provision for powers of attorney for finances, but there's no parallel provision for trusts. So trusts, as we'll talk about later, is generally going to be the main estate planning document in California, just mainly to avoid some of the delays and costs that are associated with probate. But there's different methods that people can use in order to prevent estate contests. Now, one method that an attorney taught me about a long time ago, which I've always thought was very clever, is to basically redo your estate plan often. Now, the reason for this is in California, if you are able to challenge someone's estate plan and effectively overturn the trust, it will go back to the prior iteration. So by basically doing your trust and redoing it often, not only does the contesting family member have to overturn the most recent trust, but they have to turn over every iteration down the line. So to make things a little bit, to sort of further disincentivize people from challenging the trust, another thing that I'll do is I'll figure out, well, exactly how much are you comfortable with giving this individual that you don't want to inherit from you? A lot of times the answer is none, in which case we don't include them as beneficiary. But when they give me a figure or a percentage that they're fine with the person receiving, we'll basically decide to break that up over maybe 10 iterations, and we'll gradually increase the amount that's going to be going to the person that really they don't want to inherit. But by doing that, if they do challenge the document and they get it thrown out, they actually receive less money unless they're able to successfully challenge each of the documents that we put in place. So that's just one technique that I think has been effective, or that I've seen as effective to prevent contests during my career. There's other ways where frequently we'll have people speak to a psychologist to sort of determine that they do have capacity to ensure that, to try to defeat a claim that they've been unduly influenced by their partner. That's another method. Some attorneys like to basically do videos of discussions about the estate planning documents, the reasons for the decisions. I've always kind of shied away from that method because I think that it can cut both ways. Sometimes people don't present on video because it makes them nervous. So I generally stay away from that, and I'll go with one of the other methods that I've mentioned. Now, there's a lot of issues that pop up with transgender and non-binary individuals. The self-identification issues, this one, I think it wasn't intuitive to me. So I think I'll just sort of talk about it through examples. One of my good friends, her wife is transgender, but she only presents as male at home and with family. And the workplace, she still presents as a female. And that's also goes when she's speaking with financial advisors, she presents as her birth sex. So it's just important to be just be cognizant of how someone's presenting themselves to you. You always want to ensure you don't want to misgender someone with pronouns. People, if they identify as female and you use a male pronoun, that can be quite insulting. So you just want to match how you address someone with how they're presenting themselves. There's nothing wrong with asking someone what their preferred pronouns are, especially nowadays, not everyone uses he or she. There's been a lot of people, and I've actually had a couple of clients that prefer to be referred to as they or them. So when I did the non-binary individuals estate planning documents, I'll ensure that I'll go through our boilerplate language to make sure that it's not referring to them in masculine or feminine, but to ensure that they're being referred to in a gender neutral pronoun. Another big issue, and this comes up with a lot of older LGBT individuals, regardless of whether they're transgender. But as everyone knows, when you get older, sometimes you have to go into a nursing facility or assisted living facility. And I've seen a lot of clients who are feared that, or that they're afraid they spent the beginning of their life where they were in the closet. They came out, they lived openly for decades, and they're scared that when they enter into a nursing home that they're going to be forced back into the closet and not able to present them as themselves or be open about their life with the individuals they meet there. There's a growing amount of LGBT focused nursing facilities and retirement communities. I have a lot of clients that they just don't know about these facilities. So it's good to, if those issues are going to be raised with your clients, it's good to have a few resources for them to sort of point them in the right direction so that they can find out more information on those facilities and see if it's the right fit for them. There's also a whole level of when you've been a victim of discrimination over your lifetime, you may not be trusting or as trusting as you would otherwise be to strangers. So one of the big things is just making sure you're creating a welcoming environment. It doesn't have to be where there's pride flags hanging in your conference rooms or anything like that, but it might just be treating everyone with respect, I think is what it basically comes down to. It comes to ensuring that you're not misgendering people, asking questions if you're not sure, but just trying to be open with individuals and accept them for who they are. Now, the next slide is really what I want to spend a little bit more time. There's a lot of nuance to estate planning, but I think it really breaks down into two different categories. So the first category is we have to plan for incapacity. Now this includes who's going to make medical decisions. It includes who's going to make financial decisions. And it's making sure that someone's assets are lined up to the documents so that people are able to actually use the documents as they're intended. The second, more obvious focus of estate planning is testamentary planning. Basically where a person's assets are going to be distributed after they've passed away. And also it goes back to what we talked about briefly earlier, is preventing interference with who's going to be making those decisions. Properly identifying and choosing your agent, your fiduciaries, so the trustee, the executor, who's named in the healthcare directive, who's named in the power of attorney for finances. That's probably one of the most important decisions when it comes to estate planning. Having the correct person in place can help prevent a lot of issues. So we want to ensure that the basic documents are in place in order to allow agents and trustees to step in and not to have to go to the court to have a conservatorship initiated, not to have an individual appointed to make medical decisions. Because with a lot of these things, time's of the essence, and having to go to the probate court, one, it's going to be expensive, but it also introduces a time delay. So the general documents are, everyone should have a general power of attorney for finances. This document's function is, if I lose capacity, I want to name this person to make financial decisions on my behalf. This person is also going to be entitled to file my income tax returns for state and federal purposes. And there's generally going to be a lot of other contractual things that they're able to do on my behalf. Now, with the power of attorney for finances, that's going to be limited to assets that are outside of a trust agreement. So if an asset is held in a trust, then the trustee is going to be the individual that makes those decisions. Trusts address both incapacity planning and they address testamentary planning. And what I mean by that is, in the event of incapacity, the trust is going to name who makes the decision and what happens with my assets while I'm incapacitated. Again, you want to make sure that the right trustee is put in place, so that they're using the assets as an individual would want. Trusts in California are also a will substitute, so it goes to testamentary planning. It says how assets are going to be distributed, what percentages are going to what people, if there's any specific amounts or specific assets that'll be left to an individual. It also says who's going to be in charge of distributing assets as they would like. And they may pop off additional trusts that hold assets in trust for another person's benefit, either throughout their lifetime or until a set date or a set age. Now, the healthcare directive, that's one of the other two documents that everyone in California should have. The healthcare directive, it functions as basically two documents. So one is naming the agent to make your healthcare decisions. This is typically called a medical power of attorney in other states. The second one is that it's saying, how do I want to be treated in the hospital? Here's what type of support I would want, whether I should be kept on life support after I pass, whether I want to be an organ donor, any limitations that I want to place on care, if I want to express additional wishes. These will all go into an advanced healthcare directive. In other states, this is typically going to be referred to as a living will, which is different than the other main estate planning documents in California, a will. Now, generally, if a person has a trust, there's only going to be 2 or 3 things that a person's will actually do. The first is it's going to say if there is a probate necessary, who's going to be that individual that goes to the probate court? Second, it's going to say, if I have a trust, I want my assets to be distributed to the trust. So it's not going to have all of the dispositive provisions where it says that I want my estate to be divided into shares for my children generally. Instead, it's going to tell the court to issue an order to transfer the assets to the trust, and then the dispositive provisions will be in the trust document itself. Now, as I mentioned, there's a cost issue, there's a time delay issue, and the other one is it's for privacy purposes. Generally, unless the trust is contested, the only individuals that are going to be entitled to a copy of the trust are the beneficiaries and trustees that are named in the trust document, as well as an individual's heirs. I talked about this a little bit already, but in the documents, you really want to be clear on wishes, who should be involved in making those decisions. Also, if you want to restrict access, it's important to put those restrictions right into the document. That way, it's harder for an individual to challenge the fact that they wanted the partner to make these medical decisions instead of a sister or a brother or another familial relation. Now, there's techniques that are used commonly in order to prevent contests at death. I talked about re-signing documents already. I talked about incapacity evaluations where an individual will go to a psychologist or a clinical psychiatrist and actually have a declaration that they know what they're doing. There's also sometimes if I think that it's likely that there will be a challenge, I'll have them go to another estate planning attorney that will basically review the documents, make sure that it's what the individual wants, discuss the documents with them, and then they'll sign off on a declaration that basically says, we discussed these documents and this is what the individual wants. This is just another tool that we sort of keep in our belts in order to make sure that our documents do stand up as intended. Now, prior to legal recognition of marriages between same-sex couples, there was quite a few things that LGBTQ couples would enter into in order to ensure that the other one would receive the assets or receive the assets in a tax favorable way. One of the big ones is joint tenancy. This is a very simple testamentary type of account, which a lot of people, both LGBT and heterosexual, will enter into. And it just says when one joint tenant dies, their interest will pass to the remaining joint tenant. The other main type of co-ownership is tenancy in common. There's a reason that LGBT couples would enter into tenancies in common for real property, basically to prevent a tax reassessment, property tax reassessment that is at death. There's a few specific requirements that had to be met in order to make sure that that worked. But that was a very common technique. Not on here, but there was a history of couples adopting each other to have a legal relationship between them. And then there's also a transfer on death account, sometimes called a Totten trust. And a transfer on death account would be, so it would be in my name and it would say at my death, the account should pass to whoever my intended beneficiary is. This is a way that people commonly try to avoid probate. It is effective, but there's issues with incapacity that can pop up. Now, tax planning. This is sort of my specialty, so it's very interesting to me. As I was mentioning earlier, registered domestic partners, they can have community property in California, and the income tax reporting can change. So if you're in a domestic partnership, at the state level, you're going to file a joint return. At the federal level, you're going to file an individual return. Now with community property, the publication on filing federal returns basically says that community property has to be reported 1/2 on each individual's returns. So even though an individual might be filing as a single individual, they're actually going to be reporting half of their registered domestic partner's income if it's community property. So it's something that's quirky, but this is why it's kind of important if someone does want to go through that analysis of if I enter into a marriage or a registered domestic partnership, what happens with my taxes? This is one of the reasons it's really important to work with someone who's dealt with these issues before, because that result to me was surprising when I first learned of it. Now, on the property tax, again, there's a lot of issues here, but one way to avoid reassessment, and this is for individuals, whether they're in a same-sex relationship or opposite-sex relationship, if they co-own property together, but they don't want to actually get married, to ensure that they avoid a reassessment, they can actually go from holding the property as tenants in common to joint tenancy. There's a property tax rule on point, and it basically says if you transfer property into joint tenancy property and one joint tenant dies, that the property tax reassessment will be delayed until after the death of the surviving joint tenant. So if they're not gonna, if the couple is not going to enter into a registered domestic partnership or a marriage, and they have a high difference between the fair market value of their property and their assessed tax value, this is one method that we'll commonly employ in order to prevent that property tax reassessment, to keep the surviving spouse's taxes down, or the surviving partner's taxes down, to help ensure that they're able to continue to own their joint home with their partner, or their previous home with their partner. The other method is if they own as tenants in common. This method I'll use commonly if one of the partners owns the property and they don't necessarily want to make a gift to the other partner, either because they don't want to use estates and gift tax exemption or for other reasons. I'll often have them make a 1% gift to the other individual so that they are on title as a tenant in common. The reason for this is as long as it's the primary residence, that both tenants in common have occupied it as their primary residence for a period greater than a year, that there's an affidavit that you file with the county recorder. If all of these different things are in place, then you're able to prevent that reassessment as long as the survivor basically receives the property and continues to occupy it as their primary residence. Now, on the estate tax side, as I mentioned at the beginning, previously, because of DOMA, when a surviving spouse would inherit from the other spouse prior to Obergefell, that they were not eligible for the estate tax marital deduction. Now, after Obergefell, that's no longer the case. But if they're in a registered domestic partnership, since that's not a marriage for federal tax purposes, there is no marital deduction between those domestic partners. So if they're not going to enter into a marriage and they do have a taxable estate, this does mean that there needs to be some more advanced planning in order to take care of the estate tax burden, whether that's working with putting a life insurance policy in place, going through more advanced estate planning techniques, or just through the use of charitable planning. Perhaps you name a donor advised fund as a beneficiary in order to eliminate the estate tax at death. It's an issue that needs to be examined, analyzed, and then addressed. Now, the interesting thing with community property is, as I was saying before, for income tax purposes, you have to split it between the two domestic partners. Now, with the estate tax, one of the main benefits of having community property is that you get a basis adjustment to the fair market value at death if it's community property on both halves of the property. So you would think that that would be the case with registered domestic partners, especially since they're reporting the income off the community property as being split between them. But that's actually not the case. So registered domestic partners won't receive that double, we call it a double step up in tax basis, because the actual statute refers to as between spouses. And again, registered domestic partners, not spouses for federal purposes. When there's joint tenancy property, this is another big issue when you're looking at the estate tax and running calculations. So unless you can prove contributions from both individuals, there's a presumption that joint tenancy property is 100% owned by the decedent for estate tax purposes. So again, just something to have on your radar when we're going through an analysis of whether there's going to be an estate tax owed. This is one thing we're looking at. If we can find records that show that both parties contributed, that's great. If we can't, it might be a reason to initiate a search, or we might have to do some more advanced planning from there. And then just a few tips for advisors. Again, you want to create a welcoming environment, whether that's being involved in pride parades, being involved in really just trying to get out to the community, networking. It's all a good way to make welcoming environment. I just coming to talks like this, I hope that you were able to take something away from it to sort of gain a little bit of knowledge about sort of how to interact with the community. Just doing these things, I think, helps improve issue spotting. It's important to be aware and just respect how a person is presenting themselves and how they self-identify. The reason that I think it's important to have this background to issue spot is that you can ask the right questions. These issues may not be obvious, so sometimes they have to be called out, and that's typically done through conversations. The other important one is to have a good referral list for other professionals who frequently work with the LGBT community. I have a short list that I keep of financial advisors, of accountants that I like to refer work to when I have LGBT clients that want to work with people who are experienced in those areas, because obviously there's a bit of nuance to these issues. So if someone doesn't work with LGBT clients frequently, there's the chance that these issues might be overlooked, and that's doing a disservice to your client. So I think a good referral list is really a good thing to have on hand in case you need to make such a referral for a client. And I did want to end with questions, so please let me know anything that came up or that I could speak to further, and I'd be happy to.
Thank you so much, Paul. That was a lot of information to take in, and for me, that was a lot of new information. I have a couple of questions. If you do have questions, please send them in the chat to me or to Paul. I have two here. One is shorter, and one is a bit more prognosticating. When you were talking about meeting with trans individuals and people who present differently in different settings, the question is about drafting and notarizing documents. What's your suggestion for that?
Sure. So in all of my documents, I have a clause that basically says that the feminine pronoun will be treated as masculine and the singular as plural. So if I'm working with a non-binary individual, I'll frequently put in just one sentence that says that this individual prefers to be referred to in a third-party gender-neutral pronoun. That way, if there's any question down the line, it just makes sure that the document makes sense as a whole, so that someone's not wondering, well, why are you using they instead of he or she? For the notary block, I typically don't actually scratch out the he, she, they. So that's just my practice. I don't think there's anything wrong with doing so. But just because of the shall and the statute on notaries, I typically don't scratch that out. So that's how I address that. With transgender individuals, I will ask them how they want to be referred to in the documents, because you do run into these situations where they might be out for some purposes, but not for other purposes. And they may actually want to be referred to by basically the birth gender rather than the gender that they identify with. But it might be just like with a non-binary individual, I might add a sentence that just says that this person prefers to be referred to in the masculine or in the feminine.
Thank you. The second one is much, there's quite a few questions on this. It's really, prognosticating or prophesizing, what happens if the Supreme Court turns back Roe v. Wade, and then maybe same-sex marriage, like what happens to estate taxes, what happens to all the adoptions, like where is this going if it turns back?
Sure, it's a wonderful question. I have no crystal ball, so my own personal take on it is when I read the draft opinion, that looks like Roe v. Wade might be overturned. There's a lot of the logic in there that can be applied directly to same-sex marriage, where it could be used to overturn Obergefell. I think that it's probably likely that we're going to see where at least some states are going to roll back so that same-sex couples can no longer be married. And it's going to create a host of legal issues that are going to get played out through the court system. As I was talking about that Texas case, I think that full faith and credit will require that states still recognize marriages that are validly performed in other states, but it's something that we're going to have to see how it plays out.
That's probably not as much information as people want, but again, you don't have a crystal ball. So
Yeah.
I think there's a lot of anxiety about that in the chat, to myself at least. When you, I don't know if anyone wrote questions to you. I had several questions all around that same issue. I don't know if people wrote to you directly or not, Paul.
I don't see any in the chat.
Okay. All right. So, like I said, there were many in that. So, if that's the case, then I'll wrap up the Q&A. I want to thank you so much, Paul, for the presentation. This is the first time we've done a presentation on this topic, and it was extremely helpful to me, and I hope to all the advisors out there as well. Hold on, one more question. So, it just came up in a minute. What special issues would be applicable to financial professionals, or they assume they just use the normal registration accounts, trusts, et cetera? Is there anything specific to financial professionals that they should be aware of?
I don't think there's anything specific. It is just going through, making sure that things are registered in the trust if it's available for that type of account, making sure if it can't be held in a trust, that there is beneficiary designation in place. If it's with a financial institution and there is no trust account, if the financial institution won't recognize an attorney drafted power of attorney, making sure that the client is aware of that so that they can have a power of attorney that will be accepted by the financial institution is also key.
Okay, thank you. All right, now back to my thank you. So thank you. I want to thank everyone for being here today. I want to thank you, Paul, for the presentation, for taking the time to do this. We take a break over the summer. Our next presentation will be in September with Abby Feynman, who also happens to sit on the foundation board, talking about the not so simple preparation of these types of tax returns. And we are having an in-person event for our advisor community, July 12th at the Vende Museum in Culver City. If you haven't been there, I really recommend it. One, you should go to the museum. It's a Cold War museum. It's pretty interesting. But two, we have a chance to see each other in person. I haven't seen many of you in a couple of years in person. It's outside, cocktails, hors d'oeuvres, but it's all outside. Very short program just to talk a little bit about who we are and the work of our Center for Design Philanthropy. I'd love to see you all there. If not there, then I hope to see you on our next Zoom call in September or sometime in between. If we can be of service to your clients or to you, please reach out to us. And again, Paul, thank you so much. I really do appreciate the time. I hope we'll have a chance to work together in the future. And for everybody else, thank you for being here, and I'll see you soon in person, I hope.
Thank you, Steve.
Thank you, Paul.